Good morning, my name is Philip Tune, I'm the Director of Psychiatry at Bendigo Health, and the purpose of today's brief presentation is to focus on the changes that have been introduced in the new Victorian Mental Health Act of 2014, particularly as they pertain to GPs. So that's the focus of the talk today. Alright, so as hopefully everyone knows, the new Mental Health Act commenced on the 1st of July this year, and that resulted in the old Mental Health Act of 1986 having been repealed formally. The principles underlying the new Mental Health Act are essentially around a greater emphasis on recovery and participation in treatment decisions and treatment, and the participation is by not only patients but their carers and families and other people who are concerned about them. So it's to involve patients in all decisions about their assessment, their treatment and their recovery, to allow them to make decisions about their assessment and treatment and recovery that involve a degree of risk. Now, that's always been allowed under the old Mental Health Act, but it's been formalised in the new Mental Health Act. And a lot of the changes that we're seeing have always represented good practice that we've tried to do, but they're really formalising them and introducing them into the legislation. And also carers should be involved in decisions about assessment and treatment and recovery as far as possible. In fact, they must be involved. So what's new in the Mental Health Act 2014 are both the definition of capacity and also the presumption that a person has capacity. So even if someone is made a compulsory patient under the new Act, there's still got to be a presumption when it comes to making a particular decision that they actually have capacity until demonstrated otherwise. So that's a change of emphasis and perspective compared to the old Act. There's now a capacity for patients to formally make what's called an advanced statement, which is where they, and I'll go into each of these in more detail shortly, but where they say what treatment they would prefer to have should they become a compulsory patient. There's also now a legal entity called a nominated person who's formally involved in the patient's care. The process to become a compulsory patient has also changed slightly, and that does have an impact on GPs, so that's an important part of the talk today. And just the terminology has changed, so patients are no longer involuntary, they're now compulsory. It means the same thing, but someone thought it was a good idea to change that. I'll also briefly speak about the role of the tribunal, which has replaced the Mental Health Review Board under the old Act, and make a brief comment about oversight of psychiatric care under the new Act as well. So moving on to capacity. In order to make an informed decision about treatment, the first requirement is that somebody has capacity to make that decision. And the test or the definition of capacity in the new Mental Health Act is that you have capacity, first of all, you're able to understand the information that's being presented to you and given to you, that you're able to then remember that information, that you're able to use it and weigh it up in a meaningful way, and that you can then communicate your decision. Now that communication can be verbal or non-verbal. That's very clear in the Act. But if you can do each of those things, by definition you do have capacity. Alright, the second new thing in the Act that I alluded to is the presence of advanced statements, or the capacity of patients to make advanced statements, which essentially set out a person's preferences in relation to what treatment they would prefer to have in the event that they do become compulsory. Now these statements can be made at any time. Obviously the best time to make them is when the person is stable and has good judgment and insight into their illness. They must be made in writing, they must be signed and dated, and they have to be witnessed by an authorised witness. And the Act defines who can be an authorised witness. And this is where it's relevant to you as GPs, because GP or any doctor can witness an advanced statement, so that obviously includes GPs, and you could well have one of your patients coming to you with a form asking you to witness their signature. And the requirements are that in your professional opinion the person is aware of what an advanced statement is and what it means, that they can make that statement and that you're witnessing it. Alright, the next new thing that I've mentioned is a new role of a nominated person under the Act. And a nominated person is someone who provides a patient with support and helps to represent the interests of that patient, obviously to the treating staff. They're also legally entitled under the Act to receive information about the patient, which would ordinarily be confidential. And in fact, under the Act, they must be consulted about the patient's treatment. Under the Act, there are a number of steps we need to go through in providing treatment, and a lot of that's about consulting the patient, consulting their carers, and now the nominated person is another person. And they essentially assist the patient to also exercise any rights that they have under the Act. So they function as an advocate and a support person. Again, like an advanced statement, the nomination must be in writing and it must be witnessed by an authorised witness. And again, one of the capacities of people who can be an authorised witness is GPs. So one of your patients may well come to you with a form and ask you to witness that. Okay, I'd like to now talk about compulsory treatment orders, so the way in which a patient becomes compulsory under the new Act and the changes that from the old Act when a patient became involuntary. So the new Act establishes 3 different types of compulsory treatment orders. The first one is an assessment order, which is valid for 24 hours. The second one is a temporary treatment order, which is valid for up to 28 days. And then the final one is a treatment order, which for an inpatient can last up to 6 months and for an outpatient up to 12 months. And I'll go through each of these in a bit more detail. Now that, just to remind you all, it's not that long ago, but under the old Mental Health Act there was a process of request and recommendation, and once someone was recommended they were involuntary for 24 hours, and within that 24 hours had to be seen by a psychiatrist, and they were then formally made involuntary or Section 12, and they'd be either an inpatient or a community treatment order for up to 12 months. So it's not dissimilar, but it's just a middle step now. All right, now the rationale behind the Act having these different steps is the first step being an assessment order. The thought is that for 24 hours you should be assessing somebody and confirming a diagnosis before you start treating them. So the criteria are that they appear to have a mental illness and that they appear to need immediate treatment, either for their safety, to prevent a deterioration in their health, or for the safety of the public. And an assessment order can be made by any doctor or any clinician employed by a designated mental health service. So any of our clinicians essentially can work for Bendigo Health. And this is valid for 24 hours. So much like the old recommendation that you were able to complete as GPs. That's what the form looks like. I'm not sure how clearly you can see that, but essentially it's a very straightforward one-page form which requires you to put in the name of the patient, the address to outline whether you are a registered medical practitioner or a mental health practitioner, the time and date when you examined the person. You state that you're satisfied that the following criteria are met, that they appear to have a mental illness, that they require treatment, immediate treatment to prevent deterioration or harm, that if they are made subject to the order they can be assessed, which of course they can in our region, and that there's no less restrictive way of doing all of this. And then you write down the reasons for your decision and decide either that they can be assessed in the community or need to be assessed in hospital, and the date and time that the order is made. So it's very, very similar to the old recommendation form and very straightforward. And then you fill out your details at the bottom. Now the notion that someone should be assessed for 24 hours because they appear to have a mental illness, and within that 24 hours one can determine that they actually do have a mental illness that requires them to then be on a temporary treatment order, is a good logical sequence. In reality, of course, it doesn't always happen that way, and occasionally people are very distressed or very disturbed and actually require treatment immediately, and you can't wait 24 hours. So there is still provision under the new Act to allow people to have treatment if they need it, even when they're just on an assessment order. Certainly you can do it if they give informed consent, there's no problem with that. More often, of course, people will be unable to give informed consent and they will lack capacity, which is why they're on the order. So the other ways in which one can give treatment in that first 24 hours is if a doctor who's employed or engaged by the mental health service believes that urgent treatment is needed. Now, our understanding of the Act is that if a general practitioner, as the patient's treating doctor, is acting on behalf of our service and engaging with our service in order to provide ongoing treatment, we would consider that under the Act they are in fact engaged by our service. So you don't have to be an employee of our service to be engaged by our service to treat the person. So you can make the decision in your rooms that somebody needs immediate treatment even under an assessment order. In addition to that, Sometimes people require transport to hospital by ambulance or even by other means, but they need some sedation to enable that to happen safely. Now, a paramedic can administer sedation to enable safe transport if it's within their scope of practice, or any paramedic can do that at the direction of a doctor. So you may be the doctor on the scene who has made an assessment order, arranged for transport to hospital, and then directs the paramedic to give treatment to enable that to happen safely. So that's all perfectly appropriate and legal under the new Act. Above and beyond all that, of course, there's the common law duty of care that every doctor owes to their patient, which supervenes all other legislation. So if you believe that your patient requires and absolutely needs some treatment, you give it, and that overrides everything else. So you are protected in treating people who need urgent treatment. Alright, so then the next step is, within that 24-hour period, the patient, again, very similar to the old Act, must be seen by a consultant psychiatrist. And in order to put somebody, or to move somebody from an assessment order onto a temporary treatment order, you're now completing a form that says that I'm the treating psychiatrist and I believe this person actually has a mental illness, not just appears to have a mental illness. Because of that mental illness, they need immediate treatment. The immediate treatment will be provided, and there's no other less restrictive way of doing it. So again, really very similar to the old Act. The difference being, and this is a very important difference, that these are now called temporary treatment orders and they're only valid for 28 days. Within that 28-day period, if you want a person's treatment as a compulsory patient to continue, we must apply to the Mental Health Tribunal, which has now replaced the old Mental Health Review Board. And the tribunal must hear that case within the 28-day period. If there's any delay in that, the order simply lapses and the patient's compulsory order is removed. So one of the significant differences in the new Act is that the tribunal now makes the decision about whether to place somebody on a treatment order. So a treatment order is made by the Mental Health Tribunal, and that then enables a person to continue to receive compulsory treatment. Mostly that'll happen in the community, and that can be up to 12 months, or it can be in an inpatient unit in a designated mental health service, and that will continue for a maximum of 6 months, at which point you have to go back before the tribunal. So that's a significant change from the old Act, where the treating psychiatrist would make the decision that a patient needs to continue to require ongoing involuntary treatment, and the Mental Health Review Board used to review that, and they could take people off orders, but they didn't have the power to put people on orders. So it's a power shift. Again, in the interests of protecting patients' rights. And along those lines, there are other ways in which there's greater oversight under the new Act of, I guess, the powers of psychiatrists and the powers of compulsory treatment. So the Mental Health Tribunal will be reviewing a lot more patients than happened under the old Act, because it's within 28 days. Under the old Act, it was within 6 weeks. So a lot of patients would have been treated involuntarily, discharged off section back home before they ever came before the tribunal. Now more patients will be being reviewed. I've alluded to the fact that the tribunal now has the power to make decisions, which is a difference from the old board. And the decisions are the treatment orders, which we've just discussed, but they also make the decision to administer ECT. Now that's a significant change. Psychiatrists have always had the clinical judgment and authority to make that treatment decision. We now have to apply to the tribunal to enable someone to have ECT if we think that's the appropriate treatment. There's greater requirements or capacity under the Act for patients to get second psychiatric opinions, and there's even some funding to enable people to get that in a way which they wouldn't have been able to in the past. Again, it's all about ensuring people are receiving appropriate treatment and their rights aren't being abused, I guess. And there's now a new Mental Health Complaints Commissioner specifically for psychiatric patients in the psychiatric service system. So we no longer deal with the Health Complaints Commissioner, which the rest of health deals with, and this power to investigate and respond to complaints has been removed from the Chief Psychiatrist. So it all now sits with the Mental Health Complaints Commissioner. And just finally, in terms of resources, there's a Mental Health Act handbook which is available on the Health Department website, which goes through all this information in greater detail, and there's also an inquiry line there if you had particular questions. You can you can always ring our service, ring our triage line and speak to our clinicians if you've got a question. So I hope that's addressed most of the things that are most pertinent for you as GPs, and that's a helpful presentation. Thank you.